And with that, I'd like to welcome Diane Houk and Emma Freeman of the firm Emery Celli, Brinkerhoff, Abity, Warden, Maisel, great friends of WRO and even better fair housing lawyers. So Diane, Emma, thank you so much for your patience and take it away.
Thank you, Andrew. It's great to join all of you. It sounds like you're having a very interesting morning. The 1 hour piece that Emma and I have been asked to join you for does provide continuing legal education credits for those of you who are attorneys. And at a magic moment somewhere in our presentation, we will be announcing the secret code that you need to use in order to obtain those credits. And there will be time at the end of, we'll end earlier than 1 hour so that there will be some time for questions as well. I see that Andrew has the PowerPoint up, so I think we can get started. We've organized this into 3 sections. I'll speak first about the general federal and state fair housing laws that apply in the context of residential housing and who is protected by those laws. Emma will then talk about prohibited conduct, and then we'll spend the 3rd section really focusing on disability discrimination. So to start with, whether you're thinking about the Federal Fair Housing Act or the state human rights law, there are different definitions about what is considered housing that's covered by these laws. Under the federal law, it's a dwelling. We've included the definition here, and dwellings include vacant land that may be used to construct a dwelling on, and households may have more than one dwelling. The state definition is different and frankly is broader. As a housing accommodation, it can include any building, structure, or portion that is intended to be used as a home, a residence, or a sleeping place. So some of you may be already thinking this pulls in much more easily homeless shelters, which sometimes are not covered by the Federal Fair Housing Act because they're temporary in nature. So the next slide provides a list just of the wide variety of housing then that's covered by the federal and state laws, ranging from what we think of apartment buildings and condominiums, but also to residential treatment facilities, transitional housing for individuals who are homeless, long-term vacation rentals, nursing homes, and assisted living. So the definition is extremely broad, but as lawyers, we of course have to figure out which statute does the particular situation that we're looking into, which statute covers that particular situation. Now, in the next slide, we just want to make a quick point that in addition to the Fair Housing Act, the Federal Fair Housing Act, and the State Human Rights Law, there is the Federal 1866 Civil Rights Act. This covers race and national origin discrimination. And for this law, there are no exemptions and there's no definition of dwelling or housing. This covers all real property. So whether it's vacant land or there's some structure on it, it is illegal on the basis of race or national origin to discriminate in the transferring, the sale, or rental with no exemption. So it doesn't matter if it's a single family house or an 1,100 apartment unit community. So always keep that in mind. But the rest of today, we're going to focus primarily on the Federal Fair Housing Act, which was enacted in 1968, and the New York State law. There are exemptions with all of these laws. So while you start with the dwelling, you then have to think about what might the exemptions be. And under the federal law, temporary or transient housing, such as hotels or motels, are not considered dwelling. There needs to be some intent on the part of the person using it as a dwelling to return. So if someone is living long-term in a hotel and that is where they intend to return from night to night, that may convert it into a dwelling for that one person, but the hotel as a whole is not a covered dwelling under the Federal Fair Housing Act. There are exemptions for units, buildings with fewer units. However, these exemptions are very quickly lost. The law is written narrowly. If an owner advertises, even though they're trying to rent a unit in a 2-family building, they are still, that advertising is covered by the law. And when it comes to race and national origin, this exemption does not apply. And so even though it might be available in certain limited circumstances under the Federal Fair Housing Act, the 1866 Civil Rights Act does not provide that exemption for owner-occupied buildings. And single-family homes, similarly, once again, a broker is retained and that broker is beginning to market the home and involved in the transaction, then the exemption is lost as well. And even most narrow of all is the religious organization and private club exemption. It's very, very difficult to claim these successfully, and the elements that are required for them are written out in the statute. So going to the next slide, there's another category of exemptions under the federal law, which has to do with housing for older persons. The exemption here is limited only to family status, meaning these are the types of housing which can refuse to rent to households with children, can have a policy of adults only. And there are only three kinds under the federal statute. One is 100% occupancy by individuals age 62 or older. The second is an 80% occupancy where households at least have one person in the household who's age 55 and older. And the third kind, and there aren't as many of these, is where a state or federal program has been determined by the HUD secretary that it is designed and operated to assist elderly persons. But that's a written certification process that must be attained by the program itself before it can be considered housing for older persons. And then again, as I said, the exemption is limited only to the ability to advertise and rent to adults only. So the next slide compares this to the New York State human rights law, which has a similar owner-occupied building requirement, but you can see here, the federal one is 4 units or less. With the state, it's 2 units or less. So if you have that 3 units, it might not be covered by the Federal Fair Housing Act, but it would be covered then by the state fair housing law. And to remember that that owner-occupied building exemption is only for an individual. It does not, and there's no exemption if it's an LLC, a limited liability corporation or partnership that owns the building. It's only where an individual owns the building, and that individual, not a member of their family, but that specific person who is the owner lives in the building. There's a limited exemption on sex discrimination for rooming houses, and you can see there's an exemption that permits landlords and condominiums and developers to provide discounts to promote housing for seniors age 65 and older. On to the next slide. So this is just going to be a set of 3 slides that show the differences between each of the 3 laws I've mentioned on what are the protected characteristics. So as I originally said with the 1866 law, race, color, and national origin. While very limited then, it's not a broad statute in that sense, it broadly covers all real estate transactions where there's race, color, or national origin discrimination. We then move to the 1968 Fair Housing Act, and there are more protected characteristics. Here is added religion, sex, disability, and familial status, which is households where there's at least one child. It may be a household who's in the process of adopting or having foster children come to live with them. It certainly covers individuals who may be pregnant and expecting a child, and children are defined as being under the age of 18. Also, sex discrimination has been broadened by a recent Supreme Court decision this year and guidance from HUD to include gender identity and sexual orientation discrimination as well. And then we move to the New York State law, which has the broadest, includes everything we just talked about at the federal level, but has a specific category for gender identity and sexual orientation, and then adds the other categories you see in the boxes here. I think probably of importance to mention today is the most recent addition to the law, which added lawful source of income discrimination. The definition is very broad, so it includes all lawful sources of income. This may be Social Security retirement, Social Security disability, veterans benefits, money that comes from a trust or other sources that are private but are regularly paid to an individual as income, as well as including every kind of housing subsidy or rental voucher you may think of, from the Section 8 program to the state homestead program, and other local voucher and subsidy programs that may be available. So with that, I'm going to turn it over to Emma to talk about what the prohibited conduct is within these statutes.
Thanks, Diane, and hey, everybody. So the next set of slides, as Diane said, is really an overview under both state and federal fair housing laws of specifically what conduct is prohibited. And although there are some, minor distinctions between the state and federal laws in these regards, for purposes of these slides, we're just going to talk about the basic conduct that isn't allowed. And so here we have three of the core provisions of both the Fair Housing Act and its state analogs. And the first is what I would call sort of the meat and potatoes of the Fair Housing Act, which is the refusal to rent or sell after the making of a bona fide offer. And one interesting thing about this prohibition is that it's one of the only provisions in the federal fair housing law that requires someone to be in good faith looking for housing for themselves. And that matters today. We're here working with WRO because it prohibits actions brought by testers. As opposed to the other two provisions in this page, the refusal to negotiate for the rental or purchase of housing, or the making of housing, the making unavailable of other housing, or any advertisements or statements that indicate a preference, limitation, or discrimination against any protected group. And so those latter two prohibitions, unlike the first one, allow fair housing groups like WRO and others to run tests and then themselves to be plaintiffs in any actions to enforce or to challenge unlawful policies. And an example of the last prohibition would be an advertisement that, for example, says, either we only accept applications from Jewish persons, or conversely, we refuse to accept applications from any Jewish persons. And moving on to the next slide. Pardon me while I navigate my own tech. It's also prohibited to falsely state that housing is unavailable to show, rent, or purchase. So if I'm a real estate broker and I hear from someone who I know to be a member of a protected group, I can't, on the basis of their membership in that protected group, tell them that apartment 3C on Fifth Avenue is not available when in fact it really is, and I'm showing it to other candidates and I'm just denying it to that applicant. And relatedly, and I think somewhat self-explanatorily, it's also unlawful to steer applicants to or away from either a building or a particular building complex or a neighborhood entirely, as long as your goal is to segregate populations and to create divides in housing, whether it's between one condominium or in certain areas of a city. Anything that pushes against Congress's goal with the FHA of fully integrating housing and making it equally available to all is considered unlawful. Moving on to the next slide. The prohibitions under state and federal fair housing law are not just against the explicit prohibition on sale or rental. It also requires equality in the terms and conditions that are offered to people from all over. And so you can't require terms and conditions that are less favorable to some than those that are offered to others if the basis of your discrimination is one of the protected groups that Diane was discussing. And similarly, you can't simply deny or provide less favorable services and facilities to someone on the basis of their membership in a protected group. So for example, you couldn't require a rent that was higher for an identical unit based on the fact that someone was African American. And I wanted to take the opportunity on this slide to talk about a case that our firm was involved in some years ago that really exemplifies the provision of less favorable services and facilities. And it was a case brought by an African American woman in a fair housing group who had applied to rent an apartment in New Rochelle. And before she had met any of the representatives for this apartment complex, she was told over the phone that she was at the top of a purported waiting list, and that as soon as the apartment became available, she was a great candidate. And after some frustrating efforts to get in touch with someone and not receiving callbacks, she showed up at the rental office in person. And when the rental agent she'd been engaging with observed that she was African American, they suddenly said, in fact, there's no apartment available at all, and that someone had somehow gotten ahead of her on the waiting list. And no longer were her calls returned, no longer would anyone engage with her. She had effectively been shut out of the rental process for her desired apartment. And based on her experience, a fair housing group did some testing, and they confirmed that prospective candidates who were Black, were told repeatedly that no apartments would be available for months at a time, whereas prospective candidates who were not Black were told that, oh, they were at the top of a waiting list and that they could be shown available apartments immediately. So what it became clear that the housing entity was doing in that case was utilizing this kind of amorphous and maybe non-existent waiting list in two ways. You know, for Black tenants, they wanted to use it to block access to apartments. And for white tenants, they were using it as sort of a dangling carrot to emphasize how appealing the apartment was. And so a lawsuit was brought under the Fair Housing Act, under the Civil Rights Act of 1866, the New York State Human Rights Law, and a number of other state laws, including the Westchester County Fair Housing Law. And it resulted in a really favorable settlement, which gave monetary damages to the woman who had been unable to rent. She got the apartment that she wanted free of rent for a number of years. And the entity was required to undergo various kinds of trainings and also to ensure its own compliance with the fair housing laws that Diane and I have been discussing. So I'll move on to the next slide now. And this is sort of an interesting example of a law that's still on the books, although it became somewhat less applicable after the 80s. And it says that it's illegal for profit to induce or try to induce anyone to sell or rent their home by representations regarding the entry into the neighborhood of certain people of a particular race, color, or national origin. And what this refers to is what some of you may know as blockbusting, which is an old practice that's terrible, by which white homeowners are incentivized by building developers and real estate agents to sell their homes at really low prices. And the method for convincing them is trying to show these white families that racial minorities will be taking over their neighborhoods and trying to induce fear in the white families for those reasons. And the next step in the process, which, as I said, became somewhat less common in, I would say, the 80s, was to sell the houses at an elevated price to Black and brown families who were trying to escape their own overcrowded neighborhoods. So the laws remain on the books, although the practice has dwindled, but the protection is significant, historically and still today. Moving on to slide 15. This is also, I would say, a provision that is somewhat less necessary today, but still live, which is that no person can be denied access to membership or participation in any number of different kinds of real estate or housing entities, whether it's becoming a broker, becoming a renter, a multiple listing service member, and nor can you be discriminated against on the basis of a protected characteristic in the terms and conditions of your membership or participation in those groups. So these particular provisions harken back to a time when women and people of color were actively prohibited from becoming realtors or from joining various kinds of real estate entities. And so while that is no longer common or happening frequently today, again, the law remains on the books and vital should we ever find ourselves needing it in the future. And the next two slides I'll move through quickly because they touch on what will be the final third of our presentation that Diane is going to dive into much more closely, which is disability discrimination in the housing context. So for our purposes now, I'll just say that it's unlawful under both the state and federal fair housing laws to refuse to provide a reasonable accommodation in your policies, your practices, or services when they are requested by people with disabilities. And similarly, you can't block a reasonable modification if you own or manage a housing entity when it's requested by a person with disabilities. And relatedly, after the ADA was signed into law in 1990, it set forth certain prospective requirements for how multifamily housing had to be built. And so it's unlawful under the ADA to fail to design and construct applicable housing in a way that's accessible to all people with disabilities. Oops, I'm sorry, I'm getting ahead of myself. I'm moving on to the next slide. This slide is interesting because it brings up a recent Second Circuit decision that I'll discuss a little bit right now, and I'm also happy to field questions about at the end of our panel. It is unlawful for a housing provider to fail to take corrective action regarding complaints of harassment by employees or agents of that provider. And so that's pretty straightforward, that if you manage a housing entity, you and your agents and your employees can't discriminate on the basis of any of the characteristics we've discussed against your tenants. But under certain circumstances, there is also the possibility of landlord liability for tenant-on-tenant harassment or discrimination. And an en banc decision came down from the Second Circuit recently in Francis versus Kings Park Manor. And in a few sentences, the court held that in most cases, landlords don't exercise enough control over their tenants for there to be liability when one tenant harasses another. And in that case, a white tenant brutally racially harassed a Black tenant and called him by racial slurs, sent death threats to him, and in general made him feel unsafe in his own home. But that the Second Circuit did leave open the possibility that there are certain circumstances where, based on the type of housing entity we're talking about, a landlord might have enough control that liability would be possible. So this is an area of the law, I think, that is still developing. It's going to be hashed out in New York and across the country. So it's something to keep an eye on. And the second part of slide 18 is the unlawfulness to threaten, coerce, intimidate, or otherwise take action against somebody who has asserted their fair housing rights, or importantly, for someone who's assisting others in exercising their fair housing rights. So this is sort of a two-pronged prohibition. And for example, a renter couldn't contact a real estate broker to try to blacklist a potential tenant who had spoken up about perceived discrimination on the basis of, let's say, family status. But it also functions as an employment protection. It's particularly true today when there are enormous internet entities that handle real estate, like your Zillow and like your Redfin. And so if I were an employee at one of those entities and I was instructed to do something unlawful and I pushed back, these provisions under state and federal law would give me protection against retaliation. And my final slide before I'm going to turn this back over to Diane extends a lot of these concepts we've been discussing, not only to the process of purchasing or renting housing, but other real estate related transactions, including mortgage lending, insurance, and appraisals. So you're prohibited from discriminating when you are going to make a loan or insure a property. You can't require different terms and conditions relating to loans if you're helping someone sell or buy a property. You can't discriminate in appraisals. And I would say this issue is particularly live. We have a lot of social science research, a lot of articles and data showing that when, for instance, Black people trying to sell their homes scrub their home of indicia of Blackness, that appraisers value the homes more highly. And that's an enormous disadvantage to Black and brown families who are trying to sell their homes. And so this protection, I would say, is particularly key. And then finally, there's a prohibition on a refusal to purchase a loan or to impose differential loan conditions based on someone's identity or membership in a protected class.
Thanks, Emma. I'm hoping you can log back in and unreveal your screen, because I have a question for you before I dive into disability.
Oh, absolutely.
As I was listening to your presentation, I was wondering if you could share with the group about the experience that you had representing one of WRO's clients in Westchester County, a young woman with a child who was trying to buy her first home, and problems she ran into because she had a child, which of course is a great thing for a young woman to have a child and the resources after going through a first-time home buyer program to buy her first home. And then she ran into family status discrimination.
Yes, I'm happy to. And this was one of the first cases that I had the pleasure of working on when I joined the firm that Diane and I are with. And I had the pleasure also of working with WRO as a plaintiff in that case. So the case that Diane is talking about had two plaintiffs. One was a young woman, as Diane said, whose name was Jennifer Serrano, and the other was WRO in its capacity as a fair housing entity. And Ms. Serrano had been renting in the Bronx with her daughter, who was 4 at the time. And she was trying to purchase in the Mamaroneck neighborhood. She loved its public schools, she loved its safety, and she was looking at, in particular, a 1-bedroom co-op in the Mamaroneck Gardens complex. But it turned out that both in its purchase applications and in its co-op rules, Mamaroneck Gardens would not let one adult and one child live together in a 1-bedroom apartment, although it permitted just one adult or 2 adults, quote, living as a family unit to purchase and live in such a unit. And they had similar restrictive rules for 2 bedrooms, where those applications were restricted to 2 adults and, quote, no more than 2 children. So based on the dynamics and the prohibitions we've been discussing, those are flatly discriminatory prohibitions that violate the prohibition on discrimination on the basis of family status. And so based on these representations, Ms. Serrano didn't apply for the apartment because she was told clearly she was ineligible. and she was forced for the moment to stay in the Bronx, even though the apartment she'd been looking at was a great fit for her financially and otherwise. So WRO did some testing to confirm that Ms. Serrano's experience wasn't unique, and the testing showed, exactly as suspected, that the defendant was actively enforcing a prohibition on families with children at certain numbers and in certain combinations buying and residing in apartments that had a certain number of bedrooms. And so a federal lawsuit was brought under the FHA and under the state human rights law. And as with the other case that I mentioned earlier, a really favorable result was reached. There were damages to WRO for its diversion of resources and frustration of mission in having to combat this unlawful policy. There were damages individually to Ms. Serrano, and there was an attorney's fees recovery as well. And as in the other case, Mamaroneck Gardens was required to undergo specific trainings at intervals over the period of the settlement that were run by WRO, so that we were able to retain some control over what people were being taught and how they were being educated. They had to make brochures available. They had to sponsor a WRO-run fair housing workshop. And there were record-keeping requirements to ensure that during the period of the settlement, they were complying with the provisions that they were now going to be lawfully implementing. So it was an unfortunate case for Ms. Serrano to have had to bring in the first place, but took at least that co-op one step closer to being in compliance.
Great, thank you for that example, Emma. I'm now going to turn to looking a little bit deeper into disability discrimination. If we could go back one slide to slide 20, I would like to start there. And the reason I'm starting here is, again, just as with the laws, what is the definition of a dwelling? When we come to disability discrimination, the definition of what is a disability is multi-pronged and very important for evaluating whether or not discrimination may have occurred and what might be an appropriate remedy. So at its starting point, basically a physical or mental impairment that substantially limits one or more major life activities is the common definition used in the state of New York law, as well as the Federal Fair Housing Act, as well as the ADA, for those of you who do other disability work. In the housing context, that basic definition is also broadened to include anyone who is regarded or perceived as having a disability. So even if they don't actually have the disability, but the housing provider treated them as if they do, that would be covered under disability discrimination. Or having a record of a disability referring to both medical records as well as a past diagnosis of some kind of illness, perhaps cancer, perhaps in our current days, a history of having had COVID-19, even though when applying for the housing or making a request, they no longer have the disability. If they have that record of it and they're discriminated against because of that record, then that also constitutes disability discrimination. In addition to all the requirements that Emma went through with you, all of the protections on renting and buying real estate, different terms and conditions, being told the truth about what's available to rent, and in the loan context, obtaining a loan, all of those apply in disability. But in addition, there are three kinds of prohibited conduct that are just in the disability context. The first is called a reasonable accommodation under the Federal Fair Housing Act, and that's a request to alter a rule, policy, practice, or service if the change is necessary to provide the person with a disability an equal opportunity to use and enjoy housing. A common example that I think many people think of is an apartment complex that has a parking lot and the spaces are not assigned, they're first come, first serve. An individual rents there who uses a walker or a scooter of some kind, and they say, I have a car, I would like an assigned parking spot near the entrance to the building that I live in, so that I am able to obtain parking near the door so that I can reach it given my mobility impairment. And the landlord or condominium association or co-op would enter into a dialogue with the person about their need for it, and then should assign a parking space, put in a curb cut, put up a sign, whatever's needed in order to preserve that space for the person so they're not coming home after a day of work and finding it used by someone else, as a reasonable accommodation under the federal statute. This would also be considered a reasonable accommodation under the New York state law. Now with the next slide, there may be requests for accommodations, as they're referred to under the state law, that are really about physically modifying a dwelling unit or a common area. Under the federal law, these are treated separately as reasonable modifications, but under the state law, it falls within the reasonable accommodation request. So a reasonable accommodation under state law can be about those rules, policies, or procedures, or it can be about physical modifications. Again, a common one people think of is they may live in an apartment complex that has, let's say, 6 buildings. It's 2 floors, and the ground floor units have 1 step up into the unit. And the person says, I would like to install a ramp so that I can navigate that 1 step because I have a mobility impairment. And in that instance, the landlord or condominium or cooperative would enter into a discussion with the person about what type of ramp and what's needed, and ought to grant them the ability to install it. Now, the question though for reasonable modifications, of course, is who will have to pay for it, and I'll address that in a few minutes. So when making either of these types of requests, it's important that the housing provider enter into a dialogue with the person with the disabilities. There is some great guidance from the Department of Justice and HUD in the form of a Q&A that explains definitions and process and what the expectations are under the laws. And so for those who represent, as attorneys represent housing providers, I really encourage you to get that information from the HUD and DOJ websites to be able to advise your clients. A letter from a medical professional, social worker, or other professional may be requested by the housing provider. It does not have to be a medical professional. It may again be a social worker who's providing therapy for someone with mental illness. It may also be that somebody's disabilities are readily apparent. You can see that they use a wheelchair, or you can see that they are blind and have a guide dog. And then requesting medical verification would, in many of those instances, be something that the landlord or housing provider should not be doing. But many disabilities are not readily apparent, and then of course the landlord can ask for some information, not a release to look at medical records, but some information to verify the disability. So with the next slide, the state law, as I said, is a little bit different than the federal law in the language, but it's also different in a very important piece for physical modifications. For example, if the modification is to a common area, perhaps that ramp over the 1 step that I mentioned is not to someone's individual unit, but it's actually at the front entrance of the building. Then the person making the request can ask the landlord, condominium, cooperative to pay for that ramp, that modification in the common area, and they would have to do so unless it's an unreasonable financial burden. So in a building that only has 4 apartments, and the landlord owns nothing else, it may be that the type of ramp the person needs costs a lot of money, and it may not be reasonable. But of course, in a building or an apartment complex with 100 units, installing a ramp to cover only 1 step is unlikely to be an undue financial burden. So there is some analysis that has to be done of reasonableness and burden in order to decide who will pay for the physical modifications. Also, in any complexes, apartments, or otherwise that have received federal funding, this may be community development block grants, it may be home funds, it may be, for example, the building is for seniors under the Section 202 program that HUD operates. There may be a Department of Agriculture funding for rural housing available. Then that may trigger the coverage of the Rehabilitation Act, a federal law covering disability, and the owner may have a duty to pay for modifications both in common areas and in the individual dwelling unit. So it's very important when giving advice to a housing provider about this to find out how their building was funded and financed and whether they have this heightened duty to pay for the modifications. So on to the next slide, Emma mentioned that since 1991, new construction of multifamily buildings must be built accessible when thinking about disability. And this flows both from the ADA, which covers the common areas, the rental office, the community room, any public bathrooms. It also flows from the Federal Fair Housing Act, which covers those areas plus the individual units. That's the one piece the ADA doesn't cover. So here, I'm not going to talk about the ADA requirements. I'm only going to focus on the Fair Housing Act today, but these are the 4 key pieces. It has to be a new construction, multifamily attached units of 4 or more since 1991. If there's an elevator in the building, all the units in the building must comply with these standards. If it's a non-elevator building, again, a garden style apartment building where the first floor units and then there's a second floor that you have to walk up to, only the first floor units have to comply. It mandates a set of accessible and adaptable features that must be designed and built at the time of construction and not later on demand or as people request them. And liability under this provision is both for the developer, the architect, the site engineer, anyone who is involved in the design and construction and made these decisions to create inaccessible features. So the next slide shows you the basic 7 requirements. There is a design manual that HUD has published that is something that architects can use to obtain details. There are some safe harbors that HUD has adopted over the years, which if you build your building according to the safe harbor, then it will be deemed that you've complied with these 7 requirements. But as you can see, the 7 requirements are not the ones we think of when we think of, let's say, an ADA accessible hotel room that we go to. These are really about making the unit adaptable and usable by anyone, kind of the concepts of universal design. So reinforcing the bathroom walls so later grab bars can be added if someone needs it, making sure the doors are wide enough so that people who use wheelchairs or have scooters or walkers are able to get in and out of them. Then whether an individual needs some other change to the door because of their specific needs, that would be handled as a reasonable accommodation. You know, making sure that environmental controls and outlets are not too low to the ground or too high, and making sure that there's enough maneuvering space in kitchens and bathrooms. For example, that a galley kitchen is 40 inches wide throughout the galley across from all the counters and the appliances. So again, someone using an assistive device is able to get all the way into the kitchen and use the refrigerator and the sink and the range, and then get back out of the kitchen. So these are the 7 basic requirements that are in place. And finally, I want to, actually, before I go to this final slide, I wanted to tell you about one example of another kind of reasonable accommodation in a case that WRO had a client where they assisted the family to make a reasonable accommodation for a co-op in White Plains on behalf of a young man with developmental disabilities. His family had created a special needs trust for him that supplemented his income from Social Security disability. And they approached the co-op about purchasing an apartment for him, that the trust, the special needs trust, would purchase the apartment. But the co-op had a rule of no trusts could apply or be approved for an apartment, and summarily turned them away. A WRO then assisted them to make a reasonable accommodation request, to provide the co-op with more information about the law and about their obligations. Unfortunately, when that didn't work, WRO contacted our firm, and we agreed to represent the family and this young man, and brought a complaint at the U.S. Department of Housing and Urban Development, which is one of the ways the law is enforced, both by filing in court or going to a state or federal or local agency. After an investigation, HUD issued a charge of discrimination. The case was referred to the Department of Justice, and the Department of Justice filed a lawsuit on behalf of our client. With that lawsuit, there was a resolution that included having the co-op adopt a written reasonable accommodation policy with forms for individuals to be able to ask for any kind of reasonable accommodation, not just the issue that was at hand. Training and policies for the management company that was managing the co-op, and then damages, attorney's fees, and a civil penalty paid to the United States by the cooperative and for the family, the man who was disabled. In addition, specifically in the accommodation forms, Now, when people go to this very large cooperative, it will say and ask you if you have a special needs or other supplemental trust. That can be one of the kinds of accommodations that you can request. So accommodations do go beyond thinking about parking spaces. They really go to the policies and procedures that condominiums and co-ops have and landlords have as they operate their housing. Now here on slide 20, we are on 25 or 26, sorry, 25, the 7 requirements. Thank you. Sorry for my being challenged a bit this morning on my numbers. But with these 7 requirements, we also were contacted by WRO after 3 households who had purchased condominiums in Mount Kisco at a senior retirement community. They had pre-purchased these apartments when the land was vacant and the developer was marketing them. And they were marketed as being accessible to seniors because it was a 55 and older apartment community. And they were all moving from individual homes with staircases and other inaccessible features to this building so that they would have a home in retirement that was accessible. Each of the households had at least one person who had a mobility impairment. But as the building got built and they went to final closings, they discovered that the units were not fully accessible, including the front door, which amazingly enough in a senior community, when you came to the front door, if you pushed the button for someone to let you in, you had to then walk across the room to another feature to be able to then push the apartment number you wanted. And then you had to rush back to the main door to push the buzzer again so that you could get in. And so in a senior community, the design was very flawed. That case also went through the HUD process, the same and similar as I mentioned for the family with the co-op. But this settlement agreement included a retrofitting plan because the building had been built in the 2000s, late 2000, I think 2008, 2009, way after 1991. The developer and the architect contributed financially to retrofits in common areas. For each of the 3 households we represented, they received compensation to be able to make retrofits that they needed in their apartments. The Department of Justice sought compensation for other owners who might need retrofits in their individual units. And at the end of the day, the developer and architect paid about $700,000 in addition to what they had to pay in their own attorney's fees to go through the process and to make other retrofits to the building. So these provisions about new construction can be very, very important when thinking about senior housing and accessible and adaptive living for people as they grow older. So finally, the one issue, let's go to the next slide. There are other issues related to disability besides accommodation modifications that we think of in individual cases. And I wanted to mention a couple of those. First is thinking about group homes for people with disabilities. It may be that someone could be a nonprofit developer is interested in buying a home in a community and requests a special use permit or other variances from the local zoning code as an accommodation to be able to have adults with disabilities live in a group home setting, and the local community does not provide them with that accommodation. So that duty to provide reasonable accommodations flows to local governments, counties, and municipalities, and applies to land use and zoning issues in the disability context. Another example of where this can come out in land use and zoning issues is in Westchester County. Some communities have preferences for their local residents. Some have requirements for their local residents. Maybe it's for senior housing, maybe it's for accessible housing. It could be for what some people refer to as workforce housing, a preference that individuals who already live in the community or work in the community have for the housing. One of the challenges whenever preferences are used is that in one way or another, they may violate a Fair Housing Act. So example, if it's workforce housing that's being built and there's a preference for people who are employed in the community, then that may be excluding individuals with disabilities who at a much greater rate are unable to be employed or are unemployed because employers will not hire them due to their disabilities. Also, if the requirement is that people be employed, then individuals with rental vouchers and perhaps disabled individuals with rental vouchers who are not able to work would not get that initial preference. And so they may be excluded from housing that they otherwise would be economically, financially qualified for because of the rental subsidy. That could be source of income discrimination. And finally, a local residency preference in a community that is racially segregated may discriminate based on race or national origin. And so it's important to think beyond disability, source of income, but also to race and national origin, whether these local preferences, some of them built into zoning codes, are problematic under fair housing laws. And the second sort of category or bucket of disability kinds of issues really relates to access to independent living, assisted living, and nursing home facilities, which are kind of the three generic types of retirement communities that fall under that housing for seniors or housing for older persons. It's again permitted to say they're adult only and to prohibit children from them. But unfortunately, WRO and other fair housing groups have found that some communities, both independent living and assisted, prohibit people who use wheelchairs or scooters and other mobility devices. Some of them segregate or restrict them. For example, there was an independent living community in White Plains who had a policy of not permitting its residents with wheelchairs to eat meals in the dining room with everyone else. That they had to have meals brought to their apartments. And that violates fair housing laws as different terms and conditions based on disability. And also with some of these communities, there may be issues with whether assisted living and nursing homes are providing American Sign Language interpretation for people who are deaf and providing other accommodations for different kinds of disabilities, which they are obligated to do both under the Fair Housing Act and then if they're receiving federal funds under other laws as well. So I know now Emma and I want to open it up for questions. And I have to admit, after an hour, I have forgotten who is telling us what the questions are. So hopefully Andrew will say something or Emma so that we can get started doing this.
Yeah, no problem. It's Andrew and Devin is on as well. So we're happy to help you. There are 3 questions that have been posted in the Q&A. If you want to look at those, if you have the Q&A open, or I'm happy to read them out for you.
I have it open, Emma. I'm looking at question number 1, and I think your name attaches to that.
I am happy, Kenneth, to send you the citation to that case. My Westlaw is acting up. I can give you right now in the chat the Second Circuit index number, but before we get off this Zoom, I will be able to have the Westlaw site for you. So please stand by.
And this is for the Francis versus Kings Manor Second Circuit decision Emma talked about, which is a little confusing because the Second Circuit has issued several decisions on the case, but the most recent one just came out within the last month or two, and all the judges in the circuit decided that jointly. It has a number of dissents, and it's, I think, pretty clear to anyone that the judges were not in agreement on what the standard should be, but this is at least our guidance for now. So one of the questions is, can one discriminate, as in not to rent or grant access to a building, to someone based on vaccine status, especially if you give 6 weeks notice, enough time for all people to get the COVID-19 vaccine? That's a good question. It's not one I have heard from groups or discussed at length. I've heard it phrased the other way. And of course, the vaccine is relatively new. So in the past year, the issue has been, can you discriminate against a doctor or a nurse who work in an emergency room at a hospital, not because they have COVID, but because they are at higher risk of developing COVID or might develop the symptoms. And again, I believe that's treating someone as a perceived disability. And so that would be a problem if a condominium or co-op board or landlord refused to rent to someone because they're working in a particular type of field that would provide them the more likelihood of exposure. Now that we have a vaccine, I'm looking forward to getting some guidance from HUD and some of the other groups about what that might mean for requirements. There has not yet been anything issued, but I think there will be more guidance. And of course, for individuals who unfortunately have had COVID-19 and have had what appear to be very long-term, already 6 months, a year of continuing impairments, I think that those types of impairments that we are hearing about, if that person needs an accommodation and rules or policies or procedures, that would be considered a disability. Even though COVID-19 and the immediate effects of it is short-term and temporary, which is traditionally not a disability, it does appear there are some longer-term, lasting and maybe permanent kinds of impairments that would be considered, I think, disability under the Fair Housing Act. But beyond that, I think we're all learning this together as we go through the pandemic, and I think there'll be more information coming from HUD and other agencies who enforce these laws. Next question is, do you find much opposition from the local community for group homes for developmentally disabled people? Unfortunately, we still do, and that it continues to be a problem. Almost all the time, I have at least one client who's either an individual with developmental disabilities or a nonprofit group who tries to provide supportive services for individuals with disabilities. Most recently, a new landlord bought a building here in New York City and began to renovate it. And so when the lease renewal came up for a nonprofit group that rented 2 apartments and then had their disabled consumers live in those apartments, the landlord said, "Oh, I'm not going to renew your apartments. They need to be renovated." And the group said, "Oh, not a problem. We can put these men in other buildings. We have other units. You could renovate one apartment and then we'll move them into that and move them back." The group was very ready to be flexible. And the landlord unfortunately went too far then and said, "Well, once the building's renovated, I don't think it's going to be a good look for the building to have them using the halls and the elevators and engaging with other people." And so the nonprofit group came to our firm to say, "What can we do?" And we said, "Well, you're protected by the Fair Housing Act. This decision to not renew the lease is because of the disability of your clients." And so we assisted them, and they ended up getting new lease renewals, and all of their consumers, who some of the men had lived in this building for 20 or 30 years, were able to continue to live there.
Now, I'll just piggyback on that, even though it was not directly asked. I'll say that both Diane and I also deal with other kinds of Fair Housing Act claims that are not around community resistance to group homes for folks who have developmental or other disabilities, but the idea of a hostile housing environment for folks once they are in those homes, notwithstanding how the community feels about that. And I would say that's another developing area of the law. I think Diane may have her own thoughts. We both have had these active claims over the years, but it's not all courts are prepared to see intraclass disability discrimination as actionable under the Fair Housing Act. It's a less traditional claim, but at our firm, we also see a lot of mistreatment of folks with disabilities. And so trying to leverage fair housing laws, both state and federal, in support of those folks against that discrimination, I would say is equally important post-acquisition as it is when you have landlords who are sort of misbehaving about dealing with the group home in the first place.
So I see we're coming to the end of time. We do have more questions, but unfortunately I am hesitant, Andrew, to even take more questions because then we'll go over time. And I want to be the good speaker, which stays within my time limits. So Andrew, I think Em and I will turn it back to you. You have a couple of minutes to end the morning's conference. And thank you so much for inviting us to speak with everyone in Westchester County.
Thanks to all.